Dear ladies and gentlemen, dear guests, dear panelists, my name is Goraz Justinek. I'm an assistant professor of international business here at Nova University, and I'm of course very pleased to have the opportunity of hosting you all today here at the Nova University Academic Forum with the title United Nations Business and Human Rights Treaty between Utopia and Reality. First, at the beginning, allow me to provide maybe just some short background information about today's event. Namely, in the year 2014, the UN Human Rights Council adopted a resolution by which it decided to establish an intergovernmental working group on transnational corporations and other business enterprises with respect to human rights. And the mandate, or how should I say it, the main aim of the working group was, and in a way still is, to elaborate an international legally binding instrument which would regulate within international human rights law, of course, the activities of transnational corporations and other business enterprises. Now, the Intergovernmental Working Group has had 5 sessions so far, while the last one, the 6th session, was actually taking place just recently at the end of October, and which is, of course, meaning that it finished just some 10 days back. Therefore, we would be very interested in hearing from our distinguished panelists their views on the following questions. First, I would say, of course, those who have been taking part or watching via online due to the circumstances that we have nowadays. How have you experienced the 6th round of the negotiations of the treaty? Then I would be interested to hear from you, where do you see some room and possibilities for future improvements of the current 2020 draft of the Business and Human Rights Treaty? And of course, at the end of the day, which is also the title of today's event, what do you expect from the future negotiations in this regard? In order to answer these questions, as said, we have a very prominent panel with us. We have with us Professor Claire Bright from Nova School of Law from Lisbon. Hello. We have with us Professor Elena Aparats, who is a member of the UN Working Group on the Use of Mercenaries from Geneva. Hello. We have with us Professor Nicola Scarillo Santarelli from the University of Monterrey. We have with us Professor Surya Deva, who is coming from the City University of Hong Kong and is also at the same time member of the UN Working Group of Business and Human Rights. Hello, Professor. And of course, we have with us our own Professor Jerne Letner-Černić, who is a professor of human rights here at our new university. Welcome, everybody. And as said, maybe just some logistics information, since the event should take an hour or so, meaning that I would like to ask everyone to stay within the scheduled time frame. And at the same time, I would also like to invite all the participants, really do post questions, comments, suggestions in the chat room. And I promise I will make sure that the panelists will react to them during the course of this debate. And now, without any further ado, please, I give the floor to our first speaker. And of course, in this regard, Professor Claire Bright, the microphone and the camera is yours, please.
Thank you very much. And let me just start by thanking you for the invitation. It's a pleasure and an honor to be here today among such a distinguished panelists. So in the few minutes that I have, I will focus my presentation on the second questions that you addressed to us, and in particular looking at the private international law aspects of the treaty. The reason for that choice is that in a recent study that I co-authored for the European Parliament on access to justice for victims of corporate human rights abuses in third countries, we identify private international law rules as some of the key obstacles faced by claimants in corporate human rights claims in practice. So in this respect, I see many very important improvements that have been made in the text of the second revised draft. Generally speaking, it's a text that is much more victim-centered and that constitutes an important step forwards in relation to access to remedy for the victims. However, there's still room for improvement. So let me just briefly share some of the provision with you, if I manage to share. There we go. So maybe starting with Article 9, which deals with adjudicative jurisdiction. So Article 9 provides that claimants may bring their claims before the courts of various states. They have a choice in that respect. And it mentions in particular 3 states in which do not constitute an exhaustive list in which claimant can bring their claims. The first one is the state in which the human rights abuse occurred. The second one is one in which the act or omission, one act or omission contributing to the human rights abuse occurred. And then the third one relates to the domicile of the defendant. Now, the first and the third criteria reflect a strong connection with the forum, which justifies the jurisdiction of the courts. In the first case, the courts normally of the host states having the jurisdiction of a claim that relates to human rights abuse which occurred in that state. And it's undeniable that this is a criteria that relies on very strong connection with the forum. And in many cases, it may be preferable for the victims to bring their claim before the courts of that state, although, and this is a point that I would like to emphasize, it's not always the case. The criteria of the forum of the domicile of the defendant is also a well accepted basis for jurisdiction in many countries. In Europe, for instance, it corresponds to general rules set out under the Brussels I recast regulation. And it reflects again here a very strong connection that in that case the home state has with the acts that occurred and the human rights abuse that resulted from the activity of its own companies. The second criteria is a little bit less common and I think can be more subject to criticisms in the sense that it has less of a kind of a weaker connection and can potentially give rise to more legal uncertainty because it's an act or omission that contributed to the harm, and in practice there can be many that contributes to an harm. There are other jurisdictional aspects in the new second revised draft that are, I think, extremely important and that I'd like to briefly mention. The first one, a very welcome improvement, is Article 9.3, which excludes the forum non-convenience doctrine. It's important to bear in mind that this is a doctrine that was originally introduced in the commercial context. And really, I believe that it shouldn't have any role to play when human rights abuses are involved. Even in the commercial context itself, it has been considered by certain regions as a great source of legal uncertainty, and it has been excluded, for instance, in Europe by effect of the Overzuge judgment of the European Court of Justice. We have cases since the Bhopal disaster in the 1980s that showed that this mechanism is problematic in terms of access to remedy for the victims. So I think that's a very important improvement. Another very welcome improvement is the Article 9.4, which allows to bring connected claims. So basically it allows to bring the foreign subsidiary or business partner of a parent and lead company to join the proceedings as a co-defendant when the claims are closely connected. I think, although maybe it could be phrased in a slightly clearer way, I think it's a very important provision aimed at avoiding parallel proceedings on the same fact and risk of conflicting judgments. The practical value of these various provisions is very important and not to be underestimated in my view. We have many cases, in particular in Europe, but also elsewhere, where courts are still dealing with these issues after years and years of proceedings. So they create unnecessary delay, they add cost, they had a great deal of legal uncertainty. And here I'd just like to mention the words that were quoted in the Vedanta judgment of Lord Neuberger of Abbotsbury, who said that there is a real danger that if the hearing is an expensive and time-consuming exercise, it will be used by a richer party to wear down a poorer party, or by a party with a weak case to prevent or at least discourage a party with a strong case from enforcing its rights. And I think this is particularly relevant when we look at business-related human rights claims. Finally, on the jurisdictional side, the introduction of the forum necessitatis in Article 9.5 is also very welcome and important improvement in terms of ensuring access to effective remedy for the victims. And now very briefly moving to the article on applicable law, Article 11. Again, this is very important because we have seen in practice in cases that the issue of applicable law can often constitute a significant barrier to accessing substantive justice for the victims. So here the choice that has been made in the second revised draft to reintroduce a choice for the victims is a very good one, in the sense that it allows for the victim to choose for the law that it benefits them the most. It's a little bit perhaps surprising that the choice that is mentioned here is limited to either the lex loci delicti commissi, so the law of the states where the acts or omissions that resulted in the violations of human rights occurred, and the law of the place where the defendant is domiciled. This could be, again, open to criticism. It's not very clear why the lex loci damni, the law of the place where the damage occurred, was excluded from this choice. But it is very positive that the victim has that choice. And I think this is certainly something that is important. And again, not uncommon in private international law, where we often have this possibility for parties that are considered as weaker parties, such as, for instance, consumers or employers. And just maybe just a final note, what I would have liked to see as well in that Article 11 is an express specification that would have made the measures on mandatory human rights due diligence adopted by the states pursuant to Article 6 overriding mandatory provision in order to ensure their applicability. And I will stop here my presentation in order not to take too much time. Thank you very much.
Thank you very much indeed for your presentation of the draft treaty. I think it was very insightful. And please, we will proceed with our next speaker. So Jelena, please, the microphone is yours. If I understood right, you are joining us now from Croatia, right? If I understood right, or if I misunderstood. Please, the microphone is yours.
Thank you. Thank you. So, ladies and gentlemen and dear colleagues, I would like to thank Nova Universa, New University, for organizing this panel and for allowing us to jointly examine some important aspects of United Nations Business and Human Rights Treaty draft. I also would like to greet all our distinguished panelists and, of course, all of you who joined us from all over the world and from different time zones. In my short presentation, I would like to address two aspects that seems to me very highly relevant for any future developments of the treaty and for the corporate responsibility in particular. Firstly, I would like to provide some comments on the content of the latest second revised draft treaty. And then secondly, I would like to discuss some of the strategies around the treaty negotiations and place of the treaty negotiations in the larger context of some of the latest developments around corporate responsibility. So I will start now firstly regarding the content of the second revised draft treaty. I will not go into the details, but I would like to address just some of the main issues. So in terms of the corporate obligations, the draft treaty failed to retain the minimum of the obligations or prohibitions, if you like, since the Article 6, paragraph 7, the famous Article 6, paragraph 7 from the 2019 version is eliminated from the 2020 version. And this leaves the draft without any specific reference to corporate obligations, be that under domestic legislation or what would be reasonably expected from corporations under international law. And by here, I also mean that there is no reference to international humanitarian law or international criminal law, which are actually a good legal basis for the corporate responsibility. Instead, the way it's heading with the new version, it's increasingly aligning with the UNGPs. And that to me is particularly problematic with regards to the reference to due diligence. While it is important to reiterate the importance of businesses to engage in due diligence, the language of the draft treaty as it's written only provides for limited corporate responsibility. The responsibility in the case of due diligence, even as mandatory, can only be triggered for the failure to engage in due diligence, like in a French law on corporate due diligence. This does not carry the same weight as the violations of the human rights itself, and does not have the same implications for the victims in terms of the procedures and the reparation. Due diligence is the obligation of means, not the result. Therefore, if the corporation can establish that it took all necessary measures to prevent abuses and respect human rights, for example, in terms of the internal guidelines, manuals of operations, etc., they cannot be held accountable. In addition, the violation of due diligence would rarely fall under criminal procedure. So not incorporating the failure of due diligence under criminal law will leave all the potential cases related to murder, forced disappearances, torture, sexual violence, or anything like that, right to life, without any prosecution. And finally, one of the major disadvantages of the draft's approach to due diligence is that the burden of proof always falls on the victims. And this increasingly puts the weight not just on the victims, but also on the victims' lawyers who face more and more intimidations and legal prosecutions, as we've seen it in the Chevron case. What are the positive aspects in terms of the content? The draft Article 8.2 and paragraph 3 are extremely important. They contain the most fundamental provisions that should be maintained, namely separation of the responsibilities of natural and legal person, that's paragraph 2, and the separation of criminal and civil responsibility, that's paragraph 3. The Article 8, paragraph 7 makes reference to criteria of the control that could be established, the control of the parent, that could be used to establish the control of the parent company over its subsidiary. This could be potentially a positive element. However, the way it is designed in the current draft, the concept of control can go beyond international corporate structure to include any business relationship. And this is not appropriate and realistic approach. The two types of relationships should clearly be separated. On one side, the business relationship inside the corporate structure or a corporate group, and on the other side, the business relationship outside of the corporate group, such as a supply chain. The criteria in both cases should be very different. Finally, just on the Article 15 that has not been, that not received sufficient attention by the stakeholders, on the institutional arrangements, knowing that victims cannot bring any claims or raise any issues regarding corporate responsibility. And the committee that is foreseen by the Article 15 does not have any sort of competence, not the jurisdiction, but competence over any corporation, not even in terms of reporting. I think this has not been raised enough. I would now like to address my second part, which is the treaty in terms of is the treaty reality or utopia in the current context of corporate responsibility developments. The process itself is becoming increasingly polarized. States like South Africa, which is the main sponsor, Iran, Cuba, Venezuela, they supported the process. States like USA and Australia are expressing their concerns about the process and the content, reflecting mostly business interests in their statements. In terms of corporations, they are adopting a more and more strategic shift in their strategies, and they're encouraging now delegations to reflect on whether the process might benefit from a pause, which is a very concerning element, and we know the weight of the corporate lobbying. And in addition, the process will be also, in my opinion, very likely weakened by several developments, and this may be provocative to some, but I think it's a very realistic point to observe. First, I think there is an EU mandatory due diligence. I know there has been lots of excitement about the EU mandatory due diligence, but the EU has already been very, very hostile to both intergovernmental working process, namely on one side, Business and Human Rights Treaty, and the Intergovernmental Working Group on Private Military and Security Companies, which is one segment of the whole business and human rights. And I think the European Union can only use, now they will engage in this own process, there is a risk that they might use this to undermine this treaty process. And the distancing from the treaty process and lack of support to the process can be also observed through some of the rather radical or critical statements from the UK and France during the sixth session. I'm sure you have all seen the UK statement at the first day. I have a paragraph, but I'm going to leave it for later if somebody wants more details on that. So my first, outside of the treaty process development that can undermine the treaty process itself is the EU mandatory due diligence. I don't see this as a very encouraging and positive development. The second aspect that I see is the International Court for Corruption. And while we don't know all the details to this yet, the General Assembly of the UN should meet in the extraordinary session in springtime 2021. And there are going to be discussions on the creation of the International Court for Corruptions. However, the documents that I have been receiving from on a confidential basis from some of the corporate networks is that they are going to be pushing for the passive corruption rather than active corruption, which means that if that goes through, the future court for corruption would be competent over corrupted state agents, passive corruption, and not over active corruption and active agents, those who actually bribe or corrupt. And the victims present their case in terms of they are being the victims of corruptions, which means that they could take, this could take corporations out of this context of corporate liability, and it would sufficiently undermine the treaty process in addition. I would also like to underline the important role of the civil society in the whole process. I think the fact that we are losing some of the key provisions from the text is a significant sign that there is no sufficient synergy among civil society networks. For instance, corporations have one ideological objective, that is to say no corporate responsibility. This is very clear, that is very united front from their side, while civil society faces two major challenges. One challenge is the variety of ideological claims. Should we take more, push more for the gender inclusion, more for the environment inclusion, criminal civil responsibility, which approach to due diligence should we take? So that's the first challenge, the ideological claims. And the second challenge that I personally feel is very important is that the civil society perceives itself as a negotiator, thinking they have to choose their battles in the process. In the treaty negotiating process. And I think they should not choose the battles, they should propose the battles. The positive aspect of the current draft, is that while it does not recognize the international responsibility of corporations, it could potentially open the door to additional negotiations. Article 8, paragraph 9 supports that idea that another, perhaps Rome Statute, instrument may be complementary to the current instrument. And I think this would be desirable because the current negotiations on corporate liability would be complementary rather than fragmented. So to conclude, many options are still open, but we need to act now. And I think we need to take a stronger and more united position. Thank you for your attention, and I'm happy to answer any questions.
Thank you very much for your, I think, very interesting and very specifically pointed out also topics which are very relevant for this discussion. And of course, now we move on to our next panelist. So Dr. Santarelli, please, the floor is yours.
Thank you very much for this opportunity and again for the invitation. I will try to be as ambitious, not as a treaty, but as ambitious as possible in my presentation in the 6 minutes I have left, because I would like to address the different questions posed to us. And I will address the first one at the last opportunity. So Why so? I think that the second and third ones in relation to what is our opinion in regards to the negotiations during the sixth session and the future of the treaty that we foresee are quite interrelated. And why so? Because in my opinion, it's useful to compare and contrast what has been happening there with other processes, such as the adoption of a report by the Inter-American Commission on Human Rights, which took place in December last year and was published earlier this year in 2020. Why so? Because in spite of having begun later, this process concluded much earlier and with different results. And in my opinion, this is simply a reflection and a product of the fact that treaty negotiations are like this. In fact, there is a big risk in light of some of the objections that have been raised either against the whole negotiation process or against some specific draft articles voiced by certain delegations. And if we look at this, it has to do with the fact of what motivates states when it comes to the negotiation of a treaty. In fact, comparing this will, in my opinion, show us how, for example, the objections that are still being raised against whether the treaty should encompass all corporations or exclusively transnational ones are maybe the product of certain state interests that are at stake. And the risk that we have is that we may end up with a treaty that is noble, ambitious, such as the recently, well, the one that is going to enter into force after the latest ratification, the Treaty on the Prohibition of Nuclear Weapons, which has some significant absences, those of nuclear states. And the risk is that maybe we end up with a treaty in which certain so-called global South countries participate, but home states of influential corporations are not participating. This is a risk that may happen. But even so, even if that is what ends up happening, the treaty will send a signal and expressive effect. And this can have some implications, but indeed there is a risk. And this is why some people wonder whether it's sufficient or if it's enough to remain just with the guiding principles and so on. I disagree with this viewpoint, but I think that some people compare this with the Articles on State Responsibility adopted by the International Commission because they say, well, there is no risk of states exerting an influence, trying to lower the standards, to shape them, to suit their interests. And I can see what the point is. However, in my opinion, we do need new regulations, progressive development, not only because they are going to be binding, whereas the guiding principles are not, although they do declare, for instance, in regards to the pillar to protect. But even if this is so, the guiding principles fail to address everything that needs to be done, and there are some gaps that remain. For example, when it comes to some hurdles of victims to access justice, when it comes to direct responsibilities of corporations. And this is why it is, in my opinion, good to have a treaty, which is not incompatible at all, as Professor Surya has said before, with other initiatives. And we have the Nicaragua case decided in the 80s by the International Court of Justice, among others. So now, having said this, I'm going to address a few of the specific points. First of all, what are some of these points? In the first place, I think that it's very useful that the treaty attempts to come up with a specialized approach in terms of vulnerable populations, groups, for example, when it comes to indigenous persons, and some of the non-governmental organizations proposed, for example, addressing and referring to trade unions, among others. So this is something that I see as quite positive in regards to the agreement. Now, there are some objections that were raised by certain delegations in regards to environmental rights, or for example, families of victims or human rights defenders. And this is a mistake. First of all, because in my opinion, positive international law already protects all of those categories. there is a notion of indirect victims. And on the other hand, several supervisory bodies have said that environmental related rights are already protected by human rights law. So we already have this. Additionally, we also have the Escazú Agreement in the Americas, which expressly mentions that human rights defenders must be protected and their jobs must be promoted and respected. So there are certain developments that show that these objections may be more strategically oriented than reflecting supposedly legal obstacles in relation to all of these. There is, as some may know, a disagreement I have, but I can live with, and it's related to the dichotomy between violations and abuses. I am aware of the fact that some have considered that it's useful to distinguish abuses perpetrated by corporations and violations attributable to states to make clear that states' obligations will remain in force, that they are not diminished, eroded at all by the existence of human rights abuses perpetrated by corporations. That said, there are some confusions that sometimes take place. For example, some of the delegations in the report that was, well, the draft report on the 6th session say that there may be some confusion because it's important to make clear that human rights violations may have an impact on corporate responsibility. In the end, both sets of actors can inimically affect the enjoyment of human rights, which is to me a violation. And there is an expressive effect, which is relevant because sometimes states are not responsible, but still there is a violation committed or perpetrated by a corporation. But this is something I can live with. Now, what about transnational corporations? Is it really exceeding the mandate of the working group if they are addressed? Not in my opinion. Why not? Because in fact, the mandate is fulfilled and accomplished because transnational corporations are addressed by the draft treaty. It can go beyond them, and that's perfectly normal. In fact, in my opinion, it's necessary because every corporation has the potential to operate in a transnational manner, and all corporations can engage in human rights, let's call it abuses. So it's not against the mandate, it's perfectly in accordance to it. What else can I say in relation to this? For instance, Florencia Weger from Argentina has said that the treaty does something which is very good. And it's the fact that it doesn't fail to examine private international law or matters or conflict of laws matters. Because in fact, these are important in order to determine which jurisdictions can operate and issues such as foreign non-convenience and others that have been addressed and raised by you before. So I think this is important. In the end, what is my take? Simply that if we look at the theory of Maris McDougall and Laswell on the policy approach to international law, negotiation is legally relevant in itself, regardless of whether we end up with a treaty or not. And in this negotiation, statements made by delegations are agenda setters, and they reveal much of what the different delegations are interested in. In fact, sometimes I cannot but wonder why there are so many double standards when they want to, for instance, exclude mention of foreign investment agreements, which have to be in consistency with human rights standards, considering that corporations already, when they act as foreign investors, benefit from them. So in the end, this is a fight for the law, and many of the details reveal this. But of course, we have the problem of participation. So thank you so much.
Thank you, Professor Santarelli, for this enthusiastic presentation, I have to say. Thank you also for pointing out, again, some of the very important issues in this regard. Maybe just to use this, this moment before I give the word to Professor Deva, to again invite all the participants to pose your questions and other comments and anything else you wish to pose to the panelists. You can do that by writing them in the chat room. But as said, Professor Deva, please, the microphone is yours.
Thank you very much, and thank you for the invitations. It's really a great opportunity to talk to the participants, with the distinguished colleagues here. So I think many important points are already made by colleagues, and I will try to avoid repeating those points. But I think on a couple of points I may agree or disagree, and I will make that clear where I agree or disagree. Instead of answering those three questions that were posed, I will just make some points, and hopefully those points will capture those three questions in some random order. I will make 6 points as kind of practical considerations or normative issues or negotiation issues that are relevant. The first is that the international economic system is completely broken. When we talk about trade investment issues, the issues about poverty, inequality, climate change, and all this, if you look at everything, we are completely gone, and COVID has definitely exposed it more. And if we are trying to negotiate a treaty like this in such a time, then I think we have to be realistic what this treaty can achieve and what it cannot. Because my fear is we may overburden this treaty and then it may end up not having anything. So I think, first of all, my first consideration is that we should think what we want to achieve out of this treaty. This cannot achieve everything. No treaty can achieve everything. So I think we should look for this as a first step. And if we overburden and put everything that this is our only chance and we will never get a second chance, then I think perhaps this treaty will not be able to take that burden and everything may collapse. That's my first point. My second point is that it may be critical to understand that if we want to achieve some consensus at such a highly politically divisive issue of business and human rights, it may perhaps be desirable not to put too many details where we can avoid, and let the treaty body unpack some of these details. So I think we would have to adopt this approach where we need to specify something which is critical. But if there could be a scope for constructive ambiguity, we could intentionally leave that ambiguous and allow some flexibility to states with different legal systems, different paces of reform, and then let the treaty body do the job. My third point is that I do not think we will ever have a consensus. I'm sorry, but I don't know if my colleagues will agree or not. In the field of business and human rights, I doubt very much we would have a consensus on a treaty in the near future or in the next 20 years. In fact, we never had consensus even about the UN guiding principles, and I have written about it. There was this pretension that there was a consensus, but in reality, in my view, there was no consensus. It was a manufactured consensus. So I think if a soft standard like UN guiding principles, the consensus was not very strong, I doubt it will be there. So what we need in my view is a broad support, not a consensus. So we need, I don't want to use the term the coalition of the willing, but I think we need a broad support of the states. And I see the two possibilities here. One possibility is we get European Union plus the Global South. That is one option for me. And I think here I may have a slightly different opinion from Elena. I think mandatory human rights due diligence, to me, if we get it right in Europe, that may in fact make it more compelling perhaps for European Union to support this. Otherwise, there will be a free rider issue. That's my feeling. So it might in fact work in that way. The second possibility could be that if European Union does not support, then I think it could be a treaty of the Global South. And I think it can work. Because if the Global South, let us say 60, 70, 80 countries could agree, and we can take it to even General Assembly, and if there is a treaty which is negotiated, let us say completely the host countries, but not all of them are host countries anymore. I mean, there's some home countries as well of the TNCs. It could still be a treaty with global relevance because we are regulating the corporate behavior. So even if, let us say, Cambodia ratifies it, Indonesia ratifies it, then they can control the European companies operating in Cambodia. So I think that treaty could still be a game changer in my view. My fourth point is that we should be willing to address concerns of the different delegations, but I think we need to make a distinction between legitimate concerns and the concerns which are merely excuses to derail the process. Because some countries I know for sure, I don't want to name them, they will not join this process. whatever you do, they are making demands. So they will make, let us say, demand A and B. You meet their demands A and B, and they will come up with the excuse C. So I think we need to make a distinction between legitimate issues that we should address and excuses, which I think we should not worry too much. Otherwise, we will never achieve much progress. My fifth point is that we need to expose a falsehood around implementation of UN guiding principles. I'm saying it very seriously and carefully as part of the working group, which has the mandate to implement UN guiding principles. I see this narrative that we are focusing on implementing UNGPs. My simple point is, if states were serious about implementing UNGPs, we did not need this treaty. I mean, the very fact that after 9 years of the UNGPs, we are talking about this treaty and the victims and civil society actors are asking for it simply because states are not really walking the talk on UNGPs. The NAPS process and everything else is not really delivering. My last point is that there's a lot of talk about alignment with the UNGPs, the complementary relation with the UNGPs. And I think that is where I agree with Elena point, the point she made earlier. I think we should understand what this alignment means. Alignment does not mean we copy and paste UN guiding principles. Alignment, in my view, only means that we build on the guiding principles, but I think we may need to differentiate, because I don't think Pillar 2 is a good model to copy and paste to create legal liability, especially criminal liability. And I think that is the point Elena also made. So I think we need to understand that Pillar 2 was meant to be a soft standard. And even if we have this treaty, the Pillar 2 will still be relevant because it is broad. It covers a different kind of a responsibility, which could be global, and it has almost no limits in practice. But this treaty, if it is going to include legal and civil liability, I think it cannot copy and paste Pillar 2 in my view. And let me quickly offer a couple of points in terms of prevention. How things can change a little bit, and I think that will link with my aspect of how it can complement the UN guiding principles. When we talk about this debate about TNCs versus all companies, I believe it is unrealistic as of today, even in European Union, to have mandatory human rights due diligence for each and every company, including the informal sector. It is impossible. That is an unrealistic goal. So my suggestion is we should have states encouraging all businesses to respect human rights, and states mandating some businesses to do due diligence. So I think I will make a distinction between encouraging all and mandating some. And I think that has some flexibility for different countries, what that some could mean. My second point, which I already made about legal liability, is that we need to ensure that in some cases, there is an obligation of result. And I think that is what Elena also highlighted, and I agree with that. Because due diligence obligation may look very nice, but it may end up, my fear is it may end up becoming just a legalistic compliance. And victims will still be remedialess after this mandatory due diligence. I think that is my concern. My last point, and I will finish with that, is that the treaty should also be fit for the purpose of the challenges we are going to face more and more in the next 10 years, 20 years. Issues about climate change, issues about artificial intelligence, issues about automation. So we are not getting this treaty tomorrow. We're going to get this treaty, let us say, in a couple of years or more years than that. So we have to be creating a treaty which is ready for the next couple of decades. Thank you very much.
Thank you very much, Professor, for this intervention and bringing also in this, let's say, future views as well as the realistic views of the times that we're living in and the specialties of the times that we're living in. And now, last but not least, of course, we give the floor to our own Professor Jernej Letnar-Černić, who is in a way the founding father of the, let's say, business and human rights, I can say, in Slovenia, and research in this regard. So Jernej, please, the floor is yours.
Thank you very much, Goras. Good afternoon. It's an honor to be exchanging views with all of my colleagues and friends on this very topical issue. And I'll start my presentation first from the point of view, how have you experienced the sixth round of negotiations on the treaty? And at least from myself, it was quite sobering experience. Surya mentioned possible coalition of willing. I would say that we 2 weeks ago have seen perhaps coalition of unwilling states to, to move on the issue of the binding treaty. And what I found particularly worrying is that somehow indirect impression has been created that the two blocks who are perhaps opposed in international arena on the issues, or many issues, have on this subject joined forces, and I'll explain more in detail what I mean by that. At the six sessions, we have seen statements, both written and oral, by states which could be described as superpowers or semi-superpowers nowadays in international relations, which have in a way undermined, the whole treaty process. There are some statements by one superpower which really undermines the whole process, and it basically undermines the idea of corporate accountability and access to remedy for business-related human rights abuses. And that state has been joined by another superpower from Latin America, who again was trying to undermine the whole process. So this could be described as a particular bloc which goes against the treaty, which doesn't. Those states do not want the treaty, and as Surya mentioned, probably they will not change their opinion on the draft, even though some provisions will be reformed. And then we have this second group of countries from a global north, particular member states of European Union, and also states which describe themselves as a liberal or constitutional democracy, which for some other reasons, particularly their objections against further regulation of the market, they are also very hesitant on the treaties. Claire and Yelena already mentioned statement by United Kingdom. There are several statements in this regard. So in a way, those two blocks formed a coalition which is strongly against the treaty, and the only bloc which is left supporting the current draft is are the states, the few states which were once known as states which form part of a non-aligned movement, and now they are described as a global south states such as Ecuador, Mozambique, Senegal, Egypt, and so on. And this is quite worrisome process that basically shows the current state of arts, not only in business and human rights, but also in international community, international relations, where, at least in my opinion, institutions, rules, peaceful dispute resolution do not matter a lot. But it's more important to focus on the power of a state's international community. So these negotiations, as we have seen them, were example of that, at least in my opinion. Now moving on to the issue, where are some improvements and how can we assess the current draft of the treaty? To be clear, I mean, the current draft of the treaty is improvement from the 2019 draft. And I was particularly happy to see a separate provision on access to remedy, and also particularly happy to see at least one reference to the notion of rule of law, even though it's hidden somewhere in the text and not in the preamble. It's not in the preamble, as I have argued before. But then, as you have already said and mentioned, there are several possibilities for improvement, particularly as regards corporate accountability. I agree here with Yelena that it was unfortunate that Section 7 of former Article 6 was deleted, even though this this article was then replaced by Article 8, but it's not in a way, copying the former Article 6.7. And then I would also like to see, and Jelena and Claire already mentioned that I would like to see a more clear definition of control, in due diligence. And then what I think is most important is how can we, we improve access to remedy for the victims. In here, Article 15 comes to mind concerning institutional arrangements. I would argue that this article, particularly in Section 4, concerning committee which would supervise the implementation of the treaty, has been watered down. I would like to see that the committee would have also a possibility to examine communications on complaint coming directly from victims themselves or their representatives. So there are many possibilities for improvements in reform of this current draft. And before I conclude, I would like to say a few words. How do I see the future negotiations, or is the treaty really utopia, or is a reality? Here, I would say that that the only, in my opinion, the only way for the treaty to succeed, for the draft treaty to succeed, is to have states from global north on board. That means states which have already adopted national action plans and have in their domestic legislation already, introduced due diligence legislations, or at least try to hold corporations accountable. I agree with Surya that 24 national action plans since 2011 is not acceptable, and shows that states are not really committed and serious about UN guiding principles on the business and human rights. But nonetheless, in my opinion, those states are the only bet for this treaty to succeed. We have to have states from global north on board, EU member states, and particularly the pioneers in business human rights, the states from Northern Europe, from Norway, Denmark, Sweden, Netherlands. Those states have to come on board if we want this treaty to succeed. I don't see here, Surya, I have a slightly different opinion as you. I don't see that this treaty can succeed only as a treaty of countries from a global south, mostly because of rule of law challenges in those environment. In any way, I would say that the treaty is the only possibility which we have nowadays in business human rights community to bring our discourse forward, to bring victims closer to the remedies and access to the remedies, and that's why negotiations should be continued. And all of us, and particularly those of us who work in the member states of the European Union, should try to, convince our governments to take part in negotiations. I was again not very content when I didn't see the delegation of Slovenia on the negotiations. I'd like to see that improving in the future. We have to work in our domestic environments in order to convince our states that this is worthwhile, and that business human rights needs a treaty which will not only complement UNGPs but also bring the whole field forward. Thank you.
Okay, thank you very much. Thank you all for this, let's say, first round of the introductory remarks. As you have seen, it has been a very interesting debate. Many things have been put on the table, and of course, due to that, we are also a little bit, let's say, running out of time. Nevertheless, of course, we will give another round. But still, I would kindly like to ask all the speakers maybe to to be as short as possible. And I would also read here, or just make a reflection to the two questions that we have in the chat room. The first one would be in regard from Nicholas, and he's questioning, where does the latest draft of the treaty leave the status of international human rights obligation of corporations and so on? And then we have a question from Vincent in regard of China, where he puts out that China often provides as well as loans and then the contractors and so on. I think that we in the region of the Eastern Europe and so have seen quite some of these practices in this regards. Nevertheless, please, I would like to ask all of you to kind of implement or include also maybe some reactions to this, to questions that you have. Otherwise, I will give another round if you all agree for your short, let's say, feedbacks. But I would really like to ask you to maybe really stick to a couple of minutes maybe of your reactions also to some of your colleagues and so on. So please, I suggest we do one more round and start with Claire.
Sure, just, well, this has been fascinating. I certainly think that it's really important, and of course that's what Surya was saying, to think about what is realistic, what is desirable, and what is realistic, and these are not necessarily the same things. And I can see, following closely the developments here at the European level, the question is also on the table, although in a different scope. But if we look at the draft, the first draft of the potential directive on mandatory due diligence that was released by the European Parliament, for instance, the question of corporate civil liability was left untouched and completely left to member states. And so this is something that needs to be thought about. You know, what are the minimum, the critical elements that we need to have in there, and you know, what to realistically get a decent agreement. And so I completely agree on that point. I also do believe that the developments that are occurring at the national, at the regional level are extremely important, and in the future will help hopefully get more states to the table. And I can see that with the experience of France, which is my own country of origin. I followed very closely the developments in relation to the adoption of the duty of vigilance law. As you know, it took 4 years to get there. There is extreme resistance regionally from the business lobby. And now the same big companies that we saw fiercely fighting against the law, now they're the ones that are being vocal about, we need an EU law on that. Why? Because simply they want to level the playing field. And I think that experience that we have from France, hopefully we will also see that. So if we do have a legislation at the EU level and mandatory human rights and environmental due diligence, hopefully we will also see European companies that then start asking for that as well at the international level, and hopefully it will be a positive development.
Okay, thank you very much for this, and also for presenting the situation in France. Elena, please, the floor is yours.
Yeah, I don't want to turn this into the EU mandatory due diligence discussion, but just, I mean, I do agree. I mean, there is currently 75,000 lobbyists registered in Brussels only, and they do lobbying every day. And we've seen the power of the corporate lobbying in different contexts of negotiations. So I think we can, you know, very legitimately expect that this is going to be a very complicated process and not really much in favor of victims. And then lots of issues remain to be seen. Also, how the victims from, I don't know, the jungle in some remote places, from any, you know, conflict zones in the global south can come into the EU and face corporate lawyers with which money. I mean, there's logistical and realistic aspects that we have to really take into consideration. And I mean, we have to put ourselves in the position of a victim, and not a victim who is based in, I don't know, Brussels or Paris, or discussing only the labor issues, but we have to put ourselves in the context of a victim in a remote area, far from media, far from everyone in the global south. And I think that we don't hear enough of their voices in the whole process of all of these processes. Just to answer the questions that were the China, I think treaty doesn't target any specific country. The aim of the treaty is to address certain issues that should cover more or less global issues, something that can be raised in different contexts and in different countries. If you talk about China, we can also talk about American companies. We can talk about French companies operating in Myanmar and some African places. So all of them have some aspects. So the treaty is not to target one specific country, but as I said, a context. And in terms of the human rights obligations, I think that's still very, the doctrine and the states are very unclear on that aspect. I think one regarding human rights obligations, that when corporations operate under the mandate of states, they clearly do have human rights obligations. I'm very firm on that. That's my position. I don't care if somebody likes it or not. I think there is enough legal explanations to justify this. And namely, one of the legal aspects is the contract. But I think where it's very interesting is when corporations operate in the context of armed conflicts. I think international humanitarian law can be very useful, and that's not explored sufficiently. And then at the end, we have international criminal law that can be also very useful. And just to remind you on that aspect, the International Criminal Court actually does have jurisdiction over corporate directors. And could be prosecuting. And the first prosecutor, Ocampo, announced that this is going to be one of the focus of the ICC. And we haven't seen any indictment until today. So we do have options currently. We just need to explore them. Thank you.
Okay, thank you very much. Thank you also for bringing in the answers to the questions. Now we move to Professor Santarelli, please.
Thank you. So I have mixed feelings about the different positions in regards to whether a treaty in which only certain countries participate would be a good thing or not. And actually, I think that this process exposes the limits and the flaws of a legal system that promises to address global issues. Indeed, because in the end, the fact that consent determines who participates and to what extent makes or leads to the paradox that maybe we end up with a treaty in which many states participate, but which ends up being meaningless or not adding or saying anything special, or otherwise an overtly ambitious treaty which fails to engage relevant states. So paradox, and this is what treaties always face. That said, if I may, Scott Shapiro and Una Hathaway have shown before how, for instance, the Bryant-Kellogg Pact and certain treaties can change perceptions. And if I may, I agree with the constructivist position that certain authors have in this regard, because I do think that a treaty can contribute to shaping these perceptions and reactions of stakeholders, because they will have something new to invoke in relation to certain practices. The treaty, as I said, the draft treaty is a good one. I do not entirely agree 100% with everything, which is normal. I may be in the wrong or not, but the point is that I think that it can change some practices and attitudes, even over time in regards to influential states. For example, this is something that one of the questions, the first one posed. What happens with direct obligations of corporations? This is an obsession of mine and has been for many years. I still have nightmares with this. And I think that indeed corporations do have direct obligations and they must be recognized. But the treaty works on the assumption of the incorporation and the adjustment of the legislation of state parties, which vow to or commit to hold domestically corporations accountable in certain regards. And that's fine. That's what John Knox in his famous Horizontal Human Rights Law article described as one of the indirect, well, actually the second most intense way of indirectly addressing non-state violations from the point of view of correlate obligations. And that's fine. And that doesn't exclude, even if that's what the treaty ends up saying, that doesn't exclude that under Jus Cogens customary law or what's not, corporations may have direct obligations. And I think so. And therefore, the treaty would not close the door to any recognition by tribunals and so on or future developments. So that's important. And secondly, in regards to the other question, what can be done in relation to Chinese or other companies' abuses, I fully agree with Professor Yelena, because indeed, this is something that can be predicated of actors from any place or any country whatsoever. But what is true is that, indeed, what we may end up having is the fact that we will have another tool at our disposal, at the very least, in regards to those countries that participate in the treaty that can be used to invoke and to change perceptions. At least when they participate here, even if the state is unwilling to invoke the treaty for any reasons, political reasons, corporate capture, or whatnot, victims, defenders, and others can point to the existence of the treaty. And the treaty, even for those who don't participate, reminds about possible customary and other obligations. So, yeah, thank you.
Okay, thank you very much again for this very interesting intervention. And of course, now we're moving to Professor Deva, please.
Thank you, and I will be very brief. Couple of points. My first point is that we should understand a dynamic relationship between norms creation at national, regional, and international level. So I think this treaty process is already impacting, in my view, the norm creation at the national level and regional level. And if we are able to create more legislation at the national or regional level, that is going to trigger something at the international level as well. So it's both upward and downward dynamic relationship. That's my first point. Now, in relation to the questions, I think the direct obligations, I think do exist already. So I think I would agree with Nicholas on that. And I think we ideally need those obligations recognized. And international law in future should become less state-centric. And I think non-state actors should be playing more critical role. And I would say even scholars like us, we are non-state actors. So I think we should have more critical role to play in creating norms and in implementing norms in future. That's my position as an academic. But I think for this treaty for now, I think it may be unrealistic to push too much about the direct obligations. There could be something about criminal liability for certain offenses that may survive, that may go ahead, but not generic direct obligations for everything. I think that may be too difficult. Ideally, that should happen, but I think it may not happen. Regarding China, I have a slightly different position. Despite the fact I live in China, I would say that I think China is an elephant in the room because unlike the French companies or the US companies, you cannot seek remedies in China against Chinese companies. So if there are rule of law challenges, let us say in the host country, the home country is an option as well. So I think Chinese companies pose this one challenge, which is very unique. Second uniqueness is many of these companies are state-owned enterprises, or they are linked with the government, even if they are private companies, because there's a interesting state business nexus in China, which is a socialist market economy, but it's very unique model in the world. We don't have any parallel with other countries there. So the state business nexus in China is not comparable with the state business nexus anywhere else, as far as I know. And China, of course, is a big player. So I think this is a big challenge. I'm not suggesting this treaty is going to fix it, but I think we need a solution for that. And I think I don't see any solution which is very robust for now. Thank you.
Thank you very much also for this intervention and also explaining about the China's role. I have to say share your view here. But still, of course, we have, as said, for the final comment, we have ahead of us our Jerne to maybe bring all together all the substance that was put on the table. I know it will be very difficult, but many things have been raised, many questions have been maybe posed in regard of the treaty as well as some other issues. But please, maybe if you can summarize and maybe in a way that so that we slowly conclude our session for today. Please, Jerne.
All right, maybe 3 points I can make here as a conclusion. The first point would be a procedural one. I guess all of us would like to see that more states are involved in the negotiation process, especially states from global north, from member states of European Union. Though we need those states to get on board in order to move this forward. Second point, as for substance, I would agree here with Surya that possibly one area where progress or reform could be made the fastest are the state-owned enterprises. And I was happy to see that the current draft includes the reference to state-owned enterprises. And of course, many of the questions in business human rights will not be solved by the treaty. They depend on the domestic rule of law, as all of you have mentioned. And to answer the question posed by just a minute, by Vincent. Well, the question is to improve the rule of law in the domestic sphere. Of course, that is more easier to say than to put in practice. Third point would be that with this treaty or without this treaty, the current frameworks for business human rights have to improve in order to provide access to remedy for rights holders, for victims of business related human rights abuses. All the developments at EU level are welcome, but I would wish that they also come from the side of rights holders and victims, that they get a new alternative forum where they can enforce corporate accountability for business human rights. We don't know at the moment if this treaty will be ever adopted. I'm quite pessimistic as to the short-term reality of this project, but nonetheless, I agree here with Surya that the treaty has already engineered many developments at national and regional levels, and in this way, it has already provided the added value for the rights holders and victims and the whole stakeholders in this area of business human rights.
Okay, thank you very much, Jerne, for this, in a way, also to summarizing comments. I fully agree. I think that the topic is very much relevant. I think that the debate and the negotiations on the treaty have brought some additional attention, and in international relations, this is all, I think, also very, very much important. In this sense, I would maybe suggest that we can also, in some positive signals, that maybe we hope that and of course to say a good wish to the treaty, that of course it will be accepted in some due time, and of course, if nothing else, a lot of debate in this regard will be opened, a lot of questions will be raised, and I think whenever there are new questions, new debates like similar today, of course, maybe also better solutions can come out of that. In this regard, I would suggest maybe that we can conclude with this session today, and in this regard, of course, I would like to thank one again to all of you panelists that have took your time and have joined us in this debate today in the afternoon here in Slovenia. And of course, to all the participants that have also joined us and have stayed with us in this afternoon and also posed questions and so on. To all of you, I wish all the best, stay healthy, and I hope that we see us and hear us as soon as possible, also maybe not only over online and Zooms and Skypes and this kind of tools, but also maybe in reality. I wish all the best to everyone, and thank you once again for joining us today.
Thank you, everyone.
Thank you.
Thank you.
Bye-bye.
Thank you. Bye-bye.
Thank you,
Bye.
everyone. Thank you.